Hello, everyone. This is Irv Scher, a longtime member of the ABA Antitrust section, and I'm here today to interview Jim Rill, who is a friend of some 45 years and a former chair of the section. Jim?
Irv, thanks very much for doing this. I appreciate it and look forward to being grilled by you.
Well, let's start at the beginning. Your personal background, how and when you grew up, and how and where you grew up, and where you went to school, and how you initially formed your career path.
Well, I was born in Evanston, Illinois, in March 4, 1933. And very few people know this, but my middle name is Franklin. Very few people know why my middle name is Franklin until they think about what happened on March 4th, 1933. And my parents ran out of middle names, and they decided to make somebody famous a middle name for me. And on that day, Franklin Roosevelt was inaugurated for his first term.
And they didn't make it Herbert?
So it was a lifelong, I had 3 hours into the Hoover administration, and as a lifelong Republican, I'm carrying around Franklin Roosevelt's name as my middle name. My father's a railroad man, and was in the western region of the Pennsylvania Railroad at the time, and was, you remember the Pennsylvania Railroad, and was an inveterate Cub fan, which he instilled in me. For a lifelong admiration, which I guess makes me one who's always been on the side of the losers. But
someday,
it's 101 years now. Moved to Philadelphia though when I was about 2 or 3 years old, which is the headquarters of the Pennsylvania Railroad. And since my father was a railroad man, I got to travel a good bit with him. We'd go back to Chicago on an overnight trip or up to New York, and we'd go into the dining car and be served these, at that time, very interesting and nice meals in the railroad. And it occurred to me as a maybe 10 or 11-year-old boy that, couldn't the railroads compete better if they'd bundle the meals together with the traffic and give the meals away and the traffic away at the same price, and thereby compete with the hated Baltimore and Ohio Railroad, which is running on the same lines.
But staying above cost, I presume.
We didn't get into variable cost trouble at that time. But that was literally a first interest I had in competition policy.
And how about at the point that you went to college? Were you already interested in the law?
I was interested in going to law school at the time I went to college. It became obvious to me. We'd moved from Philadelphia to Washington at this point. And it became early on obvious to me that I wasn't going to be signed by the Washington Senators, so law became a second love. Nor was Hollywood after me. So I thought law school from the very day I entered college would be something I'd like to do.
Where did you go to college?
Went to Dartmouth, class of '54.
And what did you major in?
Majored in government, which I thought was a logical step along the way. Always had an interest in history and in politics as well. And government seemed like the right major. If I had wanted to have perhaps a more fun major, I could have majored in history, or if I wanted to learn something, I could have majored in economics. But government seemed like a good compromise.
Do you feel that it helped you in your career?
The major or the college? The college, certainly. The major, moderately.
Major. And what happened when you graduated? I presume you graduated.
I graduated.
And what did you do next?
Went into the Army for 2 years. Had been in ROTC at Dartmouth. And
so you got a commission right away.
Commissioned right on the steps of Dartmouth College. All of us were lined up and given our commissions, and I reported in July of 1954 to Fort Sill, Oklahoma, as an officer in the field artillery. And after officer's basic course, I was assigned to a field artillery battalion, made an assistant executive officer in a field artillery battery. 21 years old, didn't have any idea what was going on, and I found that under me, in quotes, were a bunch of grizzled veterans of the Korean War who were A, 10 years older than I am, B, a lot more knowledgeable than I was, and C, knew it. So I said, okay, guys, you run the battery, and just don't get me into any trouble, and it worked for 2 years.
And how many men were you in charge of?
Well, ultimately I was in charge of a battery of about, I'd say 150 men.
So that was your first administrative experience.
Well, they let me pretend that I was in charge of the battery.
Okay, now when you got out of the Army, what was next?
When I got out of the Army, I went to law school at Harvard, a class of 1959. Interesting time in law school. We had maybe 500 in the class. I would say a good third of the class were veterans, not necessarily of any war or police action, but had served 2 or 3 years in the military.
Did you take any antitrust courses?
I took an antitrust course third year, and from Derek Curtis Bach, who of course became later president of the university. And it was, I think, his first year teaching at all, and certainly his first year teaching antitrust. I did some monitoring of Donald Turner's class.
But you didn't get into Donald Turner's class.
I didn't apply to Donald Turner's class. Probably should have, but it was interesting.
Did you get to meet him and know him?
Donald Turner or Derek Curtis Bach?
Donald Turner.
Later.
No, I understand that. So therefore, not at law school.
Not at law school.
And when you graduated from law school, what next?
Well, I started out immediately with a firm called Stedman, Collier, and Shannon, and it was a small Washington office. I'd say I was the second associate. There were 3 partners, Stedman, Collier, and Shannon, 2 associates, me and a fellow named Jim Bacon, who was a year ahead of me at Harvard. It was the Washington office of a somewhat larger, I think 40-lawyer or more, Cleveland firm by the name of Marshman, Hollington, Hornbeck, and Stedman. And Stedman and Collier and Shannon had gotten together when they were special counsel, staff director, and general counsel for a Senate committee that was investigating a bribery scandal for a senator from South Dakota involving the Federal Power Administration legislation. They got together and said, wouldn't it be a nice idea to have a Washington law firm? This is 1959, mind you, and there were many small firms sprouting up in Washington about this time, and this was one of them, and it seemed like a good opportunity for me. First of all, they gave me a job. That was a good opportunity. And it seemed like a more general federal practice firm than some of the other firms, which were more specialized in, for example, aviation or communications or federal power.
Well, the first few years there, what substantive areas did you get into?
Well, it started off very interestingly doing a good bit of antitrust. It wasn't a specialty antitrust firm at all. Specialty antitrust firms at that time were terms like Burks and Borkland. And, certainly Arnold and Porter had a huge antitrust practice, although I think it was like 45 lawyers at the time. But I got into several matters for Safeway involving the Federal Trade Commission.
What type of matters?
Robinson-Pavan Act matters. You remember the Robinson-Pavan Act.
I was going to ask, is that statute still in existence?
Well, theoretically, but you remember the Robinson-Pavan Act. And there were FTC investigations going at that time involving advertising allowances in the grocery business. At one time, Earl Kintner was chairman of the FTC then, and he had sent out orders to file special reports, so-called 6B orders, to 100 grocery chains, essentially asking in some detail, when's the last time you sandbagged your supplier for a disproportional advertising allowance?
And you represented Safeway in this investigation?
And 1 or 2 others in those investigations.
Did any of it result in litigation?
There were some consents. We did not sign one. But this was one of the early uses of Section 5 of the FTC Act, because while a seller, this gets a little technical, while a seller is obligated not to grant disproportional promotional allowances, it doesn't condemn any action by a buyer. And since it's not a price discrimination, it doesn't come under 2F of the Act, so they were using Section 5 to go after buyers, and they nailed, in a famous case of extending Section 5, nailed the Grand Union Company with inducing illegal promotional allowances.
Which is a famous case.
It is a famous case.
Did you continue working for Safeway after that experience?
I did work for Safeway basically up to the time I went into the Justice Department in 1989.
So it became a major client of yours.
It was a good client, yeah.
Now, in the 60s, what else did you do in the way of antitrust?
Well, we did some consumer protection work with the FTC, actually. We had, remember the guides? We did the shoe labeling guides for the shoe industry. And also did some work again in the Robinson-Patman Act area under 2C, the brokerage provision of the Robinson-Patman Act. Litigated some cases involving the fruit and vegetable industry.
Did you get any clients in that particular industry?
Well, I didn't do it for free. No, I mean, no, we had a number of the companies in the industry also who had been hit by a major, at least major from the standpoint of resource commitment, FTC investigation. And of course, it was an easy shot for the FTC because there's no competitive injury element to the brokerage provision of the Act. So it was a question of, did you get brokerage payments or didn't you? And you took title to the goods. It's almost like trying a contract case. One of my more interesting experiences was traveling into places like Phoenix and San Francisco and Kansas City, trying a case against Basil Mazinas, who was, of course, one of the icons of the antitrust bar and one of the recipients of the highest honors at the FTC, the Miles Kirkpatrick Award. Sadly passed away a while back. But he and I and a fellow named Don Serene, who was his assistant, traveled around to these cities, I by myself in a footlocker, not in a footlocker, but with a footlocker, going around, litigating the case during the day and going out to dinner at night and getting back together again and doing the same thing the next day. The whole idea of massive teams of lawyers going out trying cases just wasn't exactly in the cards at that time.
Now, about what percentage of your workload was FTC work in the 60s?
Oh, I'd say somewhere around 70%. Almost all. Very little at the Department of Justice.
And was it mainly in the fruit and vegetable industry and representing Safeway?
Did some work in the shoe industry. We had some consents in the exclusive dealing area. And a couple of cases in the steel industry. We represented some specialty steel manufacturers.
And when did your name become a firm name?
You know, you got me there. I think it was 1960, I want to say 1965.
So by the mid-60s, you were a name partner.
Right. I was quite young, but I was a name partner. It's one of the benefits of being with a smaller firm.
What was the name of the firm at that point?
Well, Stedman, the senior partner, if you will, went off on his own. Collier and Shannon left Stedman, Collier and Shannon, became Collier Shannon at the end of 1962, shortly after the Cuban Missile Crisis. No relationship. And I went with them and with one other associate, two other associates, and we set up shop in the K-Fritz building, and 2 or 3 years later I became a name partner.
And what was the full name of the firm at that point?
Collier, Shannon, and Rill in 1965.
And I'm sure over the, starting in the mid-60s, late 60s, and going on until you joined the Department of Justice, what kind of changes, if any, were there in your client base?
Well, you're talking about a long period of time now. We're talking towards towards the end of the 60s to
the
1989 is when I entered the Justice Department. But the nature of the antitrust work evolved over a period of time, and the consumer protection work stayed and was active as well. I would say antitrust was not, the merger work wasn't, the horizontal merger work wasn't terribly active after the Vons and Pabst-Platz and, before that, the Philadelphia Bank case.
The cases of the 60s.
Cases of the 60s, which, as Potter Stewart said, all we know about now is that the government always wins. So there weren't a lot of horizontal mergers being done at that time. I was still doing a good bit of distribution work, doing some trade association work.
What associations?
We represented an association called the National Association of Food Chains. And we represented an association called what's now called the Specialty Steel Industry Association.
Now, the National Association of Food Chains, that changed its name over the years also,
It merged with an organization called the Supermarket Institute and became the National Institute of Food Marketing, or became the Food Marketing Institute.
Which is still a major
In fact, it was going to be named the National Institute of Food Marketing, and Joe Danzansky, who was the president and chairman of Giant at the time, said, no, immediately the consumers will use the acronym NIFEM. So it became the Food Marketing Institute. It was basically the organization that represented all the food distribution organizations in the United States. And it was a very interesting, good client, and also provided work for other members of the industry.
And was this mainly antitrust, consumer protection, or both?
Both. We actually litigated some consumer protection cases in, I would guess, the mid-'70s. The FTC went off on a tangent attempting to try and produce availability of all advertised items in supermarkets, an escapade that was later criticized by Tim Muris and his protocol on deceptive advertising that revolutionized, I think, the deceptive advertising approach of the Commission. At any rate, represented Safeway and Pathmark and a couple of others in those cases.
And what about the steel industry?
Steel industry was largely another segment of the firm which was doing trade work. How things never change. The steel industry is concerned about imports, but we had a few. We had a few cases that involved actual beginnings of merger activity in the industry. Not to get ahead of ourselves, but in 1980, it became 1981 actually, when Bill Baxter became Assistant Attorney General and started the work on the 1982 horizontal merger guidelines. It became readily apparent that there was going to be a lot more latitude for companies to explore joinder with their competitors, mergers with their competitors, and we perceived where that might be, and in effect advised clients that they would very likely be able to get mergers through that would not have been possible in, say, the law as it was in the 1960s before the 1974. General Dynamics case and the 1974 Airlie House Conference, which I think cast grave doubt on the structural paradigm, the market share paradigm in mergers.
Now, in the 70s, was your workload again still mainly FTC work?
Good bit of FTC work. We had some steel mergers, though, involving, in one case, Cyclops, in another case, a couple of other cases, Allegheny Ludlam, which were both major specialty steel producers, and we were counsel for them.
And that was DOJ work?
Yeah, actually, going back a little bit, yeah, that was DOJ work. Steel belongs to DOJ. One of the interesting cases was really before that in the Nixon administration. The one of the very first steel mergers that took place, even under the Turner guidelines, which were still in effect when Dick McLaren was Assistant Attorney General, was a case involving National Steel's acquisition of Granite City Steel. National Steel was a very large steel manufacturer at the time. Granite City, located in Granite City in St. Louis, East St. Louis, had very large shares of carbon steel sheet. We took the case before McLaren, Dick McLaren, who was then the Assistant Attorney General.
So this would have been around 1969 or so.
Yeah, that would have been about right, 1969. And we went in and made a presentation to Assistant Attorney General McLaren. I still, only 10 years out, led the presentation. Thought I did a brilliant job. He excused the clients from the room, put his hands up like so, and said, "I suppose you could have brought me a worse merger if you'd brought me Bethlehem U.S. Steel, but this one's almost as bad. I can't possibly not challenging this." We asked for a meeting with the Attorney General. at that time John Mitchell, and Mitchell overruled McLaren.
Oh, interesting.
And the merger went through, and on the merits, and the merger went through.
How did how large was your firm at this point, the late '60s?
Oh, 20.
And how do you staff these kinds of large cases?
Well, in that particular case, we had two associates working with me. Tom Shannon, the partner, was present. We hired Jesse Markham, the senior Jesse Markham, to be our economist in the case, and ran the numbers and the theory, and were able to do it quite well.
So they used economists even in '69.
In '69, well, yeah, and Markham, of course, had a super reputation from the late '40s and early '50s, and he was very, very helpful to us.
Well, now you mentioned consumer protection cases as well during this time period, and let's
You're talking about a 20-year time period.
Yeah, let's
now,
go through the '70s now on consumer protection work. What are some of the cases you recall?
Well, you go into the more interesting cases, frankly, that came up. We had games of chance in supermarkets. That was a fetish at that time. It was in the '70s.
I'm starting there because that's after the FTC report and the Nader report.
It was after the FTC report. We had some open dating matters that the FTC was interested in. They never went very far.
What do you mean by open dating?
Date labeling on food products.
Okay.
And I don't think we got. I think we were doing mostly antitrust at that point. We didn't get back into consumer protection until really the 1980s, when we began to doing some representation of R.J. Reynolds in some of their cigarette advertising. And had some very interesting cases in that, matters in that at that time.
In the '80s. Well, let's go back now to the ABA and the antitrust section. When did
you don't want to talk about the R.J. Reynolds cases?
We'll get to that later.
All right.
When did you first become interested in the ABA and the antitrust section? And take us from there.
Well, this is going to take a while. This goes back to, again, I would say the mid-1960s.
And what happened?
Well, I had been doing some work with Ed Rockefeller, who was chairman of the legislation committee, and gone to some of the section meetings and thought they were quite interesting. And Ed asked me to be an assistant or vice chairman of the legislation committee.
That's a fast move.
Well, there weren't that many people in the legislation committee. And so I said fine and did it and gave some reports to him. And then when his term rotated off, Fred Rowe, whom I'd done some work with, asked me to take over and be chairman of the legislation committee.
Was this when Fred was
Fred was
chairman
coming
of the
in as chairman of the section, and I think that would have been 1968 or 9. Mm-hmm. It was before the Kirkpatrick report, but yeah, he would have been coming in around 1968 or 69. So I became chairman of the legislation committee at that time.
So you went to the major meetings.
Yeah.
Of the section.
Yeah. That's where I first ran into you. When we did the report on consumer class actions that Fred had assigned to Ed Barton, who was a former chairman of the section, to do a report on some proposed legislation which would have authorized widespread consumer class actions. And I don't know what your job was at the time, but I was chairman of the legislation committee, and you and I and Ed's assistant then, a young lawyer by the name of Tom Leary, got together and wrote a report, which if we were to make it a presentation on it today, we'd probably be hanged by the conservatives in the section.
So it was pretty liberal for the time.
It was a compromise. It was certainly more restrained than the proposed legislation, but we authorized a form of consumer class actions with federal approval and limitations on who could bring them and so forth, but authorized them. The council unanimously adopted the report, and the Washington Star, which was in existence at that time, since defunct, ran an editorial saying that the ABA had been captured by the arch conservatives, including me, and coming out with this report that was truly anti-consumer.
Well, the 60s wasn't a good time to be anti-consumer.
Well, I don't think the report would be viewed today as anti-consumer. I think that the consumer advocates would be dancing in the streets if they got something like this today.
And what do you recall next about your ABA career?
Basically, I think after my 3-year term as head of the legislation committee, there was a hiatus, i.e. I was put out to pasture for a couple of years, and then Ed Rockefeller became chairman of the section. We remember Ed Rockefeller, who had made me head of the legislature, put me on the legislation committee. He made me a vice chairman of the Robinson-Patman Act committee, which was then chaired by Paul LaRue, lawyer from Chicago.
This would be in the 70s now.
Yeah, and it's very active in that committee. It had authored the lead and the author of a couple of monographs.
There was a 2-volume monograph that
right.
You were on the editorial
board of the monographs, and we ran some interesting programs, one on functional discounts.
Well, this was at a time when the Robinson-Patman Act was still high on the FTC's agenda.
Well, but the star was fading. I mean, I think after, we're talking in the 70s now, and I think about this time Robinson-Patman became fell something into disuse.
So did you think the monographs were more for historic purposes than current?
Well, it was still around. No, I thought they were useful because it hadn't faded entirely, and there were still some Robinson-Patman cases. I remember, I think it was around this same time that the last blast of brokerage cases came out. Basil Mazinas, of whom we've spoken, was then executive director, but he'd managed to steer the Bureau of Competition into some brokerage cases involving some major food chains and some field brokers in California. And I think that was one of the last litigated cases in the area of 2C, which we actually won at the administrative law judges level, and the commission kind of threw up its hands and said, well, we don't agree with everything the administrative law judges say, but we're not going to pursue these cases any further.
You think Phil Ellman had a strong influence on that?
I think about this time Rand Dixon, the chairman, had gotten some religion on the scope of the Robinson-Patman Act.
That's interesting.
Everett McIntyre dissented, of course.
Well, yes.
Commissioner McIntyre, but I think Chairman Dixon read the handwriting on the wall that these cases weren't going to go very far if they were taken into court at this stage. And
now, at this point, as still a young antitruster,
well, getting a little gray,
in the ABA antitrust section with the leaders of the antitrust practice across the country, did you have any mentors in particular that you recall?
Yeah, very much so. First of all, I want to give credit to my partner Tom Shannon, since deceased, who, not an antitrust lawyer, more of a trade lawyer, but had enormously good judgment and enormously good sense of how a law firm ought to operate and how client relations should be developed, and I think taught us all a lot.
And you had your artillery experience.
Well, I didn't use that on the clients or even on the opponents, but in the antitrust mentoring at the firm was not great. I mean, none of my senior partners, neither Shannon nor Kyer, were particularly antitrust lawyers. And fundamentally, I got my mentoring out of the ABA antitrust section. In particular, Fred Rowe was very much a mentor. Of course, he was Mr. Robinson-Patman before he became Mr. Lots of other things, and wrote the icon book
in the early 60s.
Right, and we had gotten together on a matter we were working on. He was representing the grocery manufacturers. Another one who I mentioned as a mentor is Tommy Austern, Covington and Burling, who was representing the national canners, and I was representing the food chains in a major government investigation that was stimulated by a senator from Wyoming by the name of Gail McGee. The organization, the investigation was called the National Commission on Food Marketing. And the effort of the National Commission on Food Marketing was to blast the food chains through the grocery manufacturers and the canners, putting the squeeze on agricultural producers, and at the same time squeezing consumers at the other end of the funnel. We were spending a lot of time working with great Americans like Roman L. Haruska, senator from Nebraska.
I remember him.
And others, writing papers for them to try and undercut the majority of the NCFM. But it was a very interesting project, and I really admired both Fred and Tommy and the work that they'd done. They taught me an awful lot, and both took an interest in me as a younger lawyer. It was very, very interesting.
So for our viewers, you're saying that you can learn a lot from the experienced antitrusters in the section.
Well, I did both, and in the section as well, attending the meetings and talking to them and getting various assignments from them. I'll also say your partner, Ira Milstein, is someone who was something of a mentor to me as well as I'm sure to you.
Well, that's nice to hear.
Because his style and his openness, his vivacity, and knowledge and expression were really admirable. Really something I could learn from.
Were the spring meetings already a major event in the 70s?
Well, not the mob scene they are now, but certainly they were very much major events. They always drew. That was the first start of what's now called the Enforcers Panel, I think. It was called 60 Minutes. And at this time, I remember, I think the first one ran with Lou Engman, who was chairman of the FTC.
It takes us back to Nixon.
It takes us back to Nixon because Lou succeeded Miles Kirkpatrick as chairman of the FTC, and I think he was the first one to do the so-called 60-minute programs. Remember the 60-minute programs?
I do.
And they were beginning at that time. They were a high point of the spring meeting.
And what about after your time as Robinson-Patman Committee chairman? What was next?
I went on the council. I think I was a class behind you, or two. And
I know we were contemporaries on the council.
We were on the council at the same time. I remember one time you were talking about being a great compromiser in some issue, and you said you were the Daniel Webster, and I had to say, no, Irv, you mean Henry Clay, but that's all right.
So you spent your time on the council, and what was next at the ABA?
I was actually on the council. I had several interesting assignments on the council. I was still responsible for putting on a fairly major Robinson-Patman wrap-up program, which I think went very well. I did a particular session on functional discounts, and it was the only time that I was cited by the Supreme Court was the paper I did there for the wrong proposition in the Hasbrook case. But that's all right. And then I was assigned by Carla Hills when she was chairman of the section to develop a program for liaison with other sections so that we could work better with them in attempting to get programs through the sections and work with blanket authority without getting bushwhacked by some other section and putting some of our proposals forward.
You mean like reports to the Hill?
Reports to the Hill, or reports generally that required some imprimatur from the ABA. And so I put a report in that said we've got to assign committee chairs to do the liaison work. It wasn't really a genius report, but it was well received, and I think that got some notice from the leadership of the section.
And now your time is up as counsel. What was next on the council? What was
next?
I
became finance officer.
Based on all of your accounting experience.
Right, my non-existent accounting experience. Talked to my wife, but the basic problem there was that we were almost broke.
Don't tell us why.
Well, there were some very elaborate trips and dinners that were taken by the section at that time.
Sounds like the current economy.
And well, no bonuses. But lots of elaborate trips and dinners, and at that time a very excellent publication, the Antitrust magazine, was started, but it was given away, and of course the journal is given away to members, and the magazine is given away, so there was no money in that. And the section budget was actually sort of saved, at least temporarily, because out of the blue, John Briggs, who was then in charge of publications, came up with an update of the developments volume, which was sold, and put some money in the section's coffers so that I didn't go bankrupt as finance chairman, and that led to the next step,
which was
to be chairman-elect of the section, and that was. Well, 1986, 87, because I was chairman 87, 88.
Well, okay, now you're chairman of this body. And what do you recall about your chairmanship? What, if anything, was accomplished during that 1 year?
I don't know what was accomplished. We had we did some good things. We got the whole ABA to come out for repeal of the McCarran-Ferguson exemption.
That's still happening.
Well, more hopeful now than then, but yes, we got the whole ABA to come out for repeal of the McCarran-Ferguson exemption. And we did if you will, a 20-year reprise of the Kirkpatrick report, which we talked about earlier, called Kirkpatrick 2. We got Miles Kirkpatrick to chair it, and came up with a report on how the FTC had adhered to the recommendations of the Kirkpatrick report, and it's performed generally a positive report.
It's about 20 years after his report.
About 20 years after. It was an interesting group on it. Bob Potofsky was a member of the group. Tim Muris was a member of the group. That's where they got to be friends, literally. And we had a nice group. Cass Sunstein was on it. And our director was Steve Calkins.
And my recollection is you initiated the relationship with the state attorneys general.
Well, that came when I was actually chair-elect of the section. It was thought that since there was not the state AGs were coming on, and the relationships with the then leadership of the Antitrust Division and the Federal Trade Commission were perhaps in need of some help. And it was thought that why don't we put them on why don't we put the state AGs on the council? One of our senior colleagues suggested, why don't we make the state attorney general a member of the council? And became fairly early on obvious that no state attorney general particularly wanted to waste his time sitting on the council of the antitrust section by his perspectives. It showed how short-sighted they were. So the deputy attorney general, who at the time would be in charge of the state antitrust task force, was invited to become a member of the council ex officio. Now, of course, you have members of the council who are state deputies who are on the council in their own right. But we made that motion. There was at the time, you can imagine, not always a total unanimity on that particular issue, but it was a great move, I think. So
now we're at the end of your chairmanship, and
the start of yours,
and suddenly Jim Rill is no longer in private practice. Tell us about what happened and why.
Well, you were all part of it. There was some concern among the council as to the appointments that were being made to the FTC and the Department of Justice, and the extent to which, I'm talking in the late 1980s now, some were grumbling about inactivities. That sound familiar? And
well, we know whose presidency was involved in the 80s.
And then, I think it's a bum rap, but at least there was some grumbling. In any event, the states were also becoming increasingly active. It was a concern that the states were invading the field more than the federal agencies. So the council, a couple of members of the council said, let's write a letter to the president-elect, George H.W. Bush, and tell him he's making terrible appointments, and we need to get better people in there. You and I both said, that's not really the way to go about this. We should, advise them of the importance of the chair of the FTC and the assistant attorney general, but let's do it in a more informal way. So you, as the chair of the antitrust section, and I, as the immediate past chair, were delegated to go down and talk to Boyden Gray, who was then the chief of transition. He'd been, of course, chief counsel to the vice president. and was then chief of transition for the president-elect.
Who was George Bush?
Who was George H.W. Bush, right. Please. You, properly primed, said, you know, we made the pitch that these are important positions and ones that you need to pay attention to because of what's happening out there. And you, properly primed, said, well, you know, why don't you make Jim head of the FTC? And I said, no. And Boyden said, why don't you do it? Because then I wouldn't have to worry about that anymore. And I said, no. Still a young firm, small firm, can't do it. No. Talked to some people that weekend, and then you, among others. And then on Monday, the following Monday, this is like a Thursday, on the following Monday, I got a call from Mike Ullman, who used to be a law clerk with us at Collier Shannon, but was then running transition for the Justice Department, saying, well, we agree you shouldn't be chairman of the FTC. Well, thanks, Mike. I figured that one out for myself. We want you to be assistant attorney general. And I went through this usual stuff about, well, you know, with a small firm, I can't really do it at this point, and I'm not ready for it. He said, well, do me a favor. Send me your resume in, and we'll use that as a litmus against the people that the President's-elect Personnel Office is sending over. And he'll say, and you know, a resume is a resume. So I wasn't born yesterday, so I figured the minute I put my resume in, I would be in play. So I talked to my wife, Betsy. I said, you know, what do you think about going into the government? She said, well, people don't work very hard in the government, so that's okay.
Right.
I didn't disabuse her of that. She learned later on how false that one was. But so that's what happened.
So you became head of the Antitrust Division. Time starting to run out, so why don't you tell the viewers what you believe were your major accomplishments during your time at the Antitrust Division, which was about 4 years?
First of all, 3 years.
3 years.
So it's still longer than the average. I can't say that I had major accomplishments without the presence of an enormously competent bunch of people that worked with me. I mean, deputies like Mike Bedane and Judy Wally, Bobby Willig, Janusz Ordover, later Charles James, Paul Dennis.
That's an all-star team. They didn't need you.
Well, exactly. I was the front for that crowd. Well, what are the accomplishments? I think the first set of guidelines, the horizontal merger guidelines in 1992, which were a modification, I think an improvement on basically the 82 guidelines, which were, of course, the lodestone guidelines. Because they were jointly with the FTC and because they moved further away from pure structural analysis and more into competitive effects and some improvement of entry analysis was a major accomplishment.
How about cases?
ATP, although like Moses not being able to enter the promised land, I wasn't there when the case was brought, but I was a major progenitor and cheerleader of the case. Airline tariff publishing. Collusion case.
And what was significant about that particular case?
Well, it was a case that involved the exchange of information that, in our view, could only be made for the purpose of fomenting price collusion among the airlines. We located particular messages back and forth through the system.
So this was electronic?
Electronic messaging through the first electronic system, too, where a first-day sale would be at a certain time, and then the last-day sale would be 1 hour later.
And you consider that to be collusive.
The only purpose of that, obviously, was to send a message to the airline, not the consumer, as to what would happen, and that would be sent into, and if there wasn't a proper response, then there would be a similar message sent back into the original sender's hub market, and, you know, did you get my message?
And that resulted in a consent decree.
Consent decree, yeah.
Now, what about policy matters other than the merger guidelines?
Well, before we get to that, there's also the Ivy League school case, which was an interesting case. The Ivy League schools, we felt, and I think accurately, were, and quite overtly, colluding on the extent to which they give financial aid, candidate by candidate, in special meetings of the admissions office people in the Ivy League schools.
We won't talk about who their counsel was.
No. Although I tell you that one of the counsel for Cornell was Tom Leary, and he was very instrumental in bringing about a resolution of that case through consents. I have to tell a quickie on Dartmouth, which is my alma mater.
Go ahead.
The president of Dartmouth was a classmate of mine, and we had talked some. And the admissions officer, the Dartmouth alumni clubs had an annual get-together to raise money. They bring up all the heads of the alumni clubs, and the admissions officer had his 3 minutes of glory, which he took 30 minutes, and he said, I'm not going to talk about this lawsuit on our financial aid agreements. And he spent the next 10 minutes talking about it, and he said that the worst thing about it is that it's a former alumnus of Dartmouth College that brought these cases. I wanted to send him a note saying, if I'm a former alumnus, you're not going to use the rule, stop sending me the Dunning letters. But I didn't do that. I thought that probably would be bad. So you want other policy?
Yeah,
well, of course, we negotiated the 1991 agreement with the European Union, Antitrust Cooperation Agreement with the European Union.
Was that the first one?
No, there were cooperation agreements before, one with Canada and one with Germany, but this was the first one that had the positive comedy notion spelled out in express detail, and it became the model for a fairly large number of other cooperation agreements that have since been entered into with the Department of Justice and antitrust enforcement agencies and other nations in the world.
And this was with the entire EU?
Yeah. It was originally proposed in a different way by Sir Leon Britton, and then worked out in negotiations between me and Klaus Ehlerman.
Well, let me ask you this for the younger
attorneys.
Director
General at the time.
Let me ask you this for the younger attorneys.
Well, you are everybody's a younger attorney.
Who may be watching this, and that how did you think your experience in the antitrust division helped you in your later career?
First of all, from the standpoint of feeling some level of accomplishment and some level of being able to contribute, it was the best 3 years of my professional life. As far as learning, as far as experience, I'd done very little criminal antitrust work before I went in. And of course was exposed to that through Judy Wally and Joe Widmar, and learned a good bit about that. And how can I express the value of getting a free tutorial for 3 years from Bobby Willig and then Janusz Ordover in economics? Just enormously good. And then also the involvement in international antitrust, which was just beginning to become a major factor. I went in 1989, came out in 1992, and 1989 was the first year that the European Union had adopted its merger regulation. So even Europe had just then gotten into, although they did it under the Treaty of Rome, it's the first time they had a regulation dealing directly with mergers. Since then, of course, we have over 100 countries with various merger regulations. We were sort of there present at the creation, if you will. And involved also in the structural impediment initiative talks with the Japanese government, which I think many in Japan think actually put the JFTC back on the map as a major force in Japanese competition and economic policy. So that experience of being there in international antitrust at the real threshold of enormous significance that it's since embraced was a tremendous bit of excitement to me and a tremendous learning experience.
And after you left the division, what did you do?
I went back to Collier Shannon for 10 years, and then about 10 years, and then in 8 years. And then in 2000, some of us went over to Howrey Simon, where we are now.
Now it's Howrey LLP.
Now it's Howrey LLP. It was then Howrey, Simon, Arnold, and White, because they had just made an acquisition or merger with Arnold, White, and Durkee out of Houston. And I had a lot of friends at Collier Shannon, and of course my name was on the door, so it was kind of a wrenching decision to make. But Howrey offered the strong litigation base. It was an excellent antitrust firm. I think we made it an even better antitrust firm by going over, but very strong litigation base, a strong intellectual property base, particularly with the arrangement with Arnold, White, and Durkee. And in the discussions with Howrey, it was clear that they were prepared to open up in Brussels, which was tricky because we'd be like the 30th firm or more in Brussels. and they agreed that that would be something that they would do. And Collier Shannon really wasn't in a position to provide a platform in any of these respects.
And you had that recent experience.
I thought that given the globalization of antitrust and the importance of litigation and the link between antitrust and intellectual property, which has become increasingly obvious, that we needed the broader platform. Howrey was prepared to take every lawyer out of Collier Shannon. But the other major part of Collier Shannon, the International Trade Group, decided for their own, I'm sure, valid reasons that they wanted to stay independent. So 30 of us went over to Howrey Simon.
And you're still there.
18 of us are still there after 9 years, and I think that's a pretty remarkable record given the volatility of law practice today.
Working full-time?
Well, depends on who you talk to. My wife says I'm working more.
Well, obviously you've had a wonderful career, tremendous accomplishments both in private practice and in government service. Let me ask you one final question. What kind of advice would you give to budding young antitrust attorneys looking for themselves as to where to go and what to do in this area?
Well, this is not a paid advertisement, but I think for my own purposes, one of the best decisions I ever made was to get active in the antitrust section of the ABA. It was a huge learning experience. It was a wonderful development of relationships, including with people like yourself. I think kind of an exciting opportunity to do some work in the field and to learn more in the field as time progressed. So that would be certainly one. And I think firms, by the way, ought to encourage that in every possible way. But I think that's certainly one strong recommendation.
And how about going right into the government versus going into private practice?
Well, I think everybody should seriously consider having some experience in the government. It almost, I guess I had two experiences in the government. One was in the field artillery, but if you could enter the government later on at the level that I entered the government, I would strongly recommend that. But,
I'm talking about budding young antitrusters.
But no, I think we've had a number of people in our firm that have gone into justice or FTC and returned, and I think that the experience has been real good for them.
Well, thanks, Jim. It's for all of your candor. It's been a very enlightening experience for me, and I'm sure that the viewers are going to enjoy this conversation.
My pleasure, Irv, and thanks for taking the time to do this with me.